Good day, everyone! Are you curious on how obligations can be extinguished? Then tag along. We will be discussing Chapter 4, Extinguishment of Obligation. Here in Article 1231, obligations are extinguished 1. By payment or performance 2. By the loss of the thing due 3. By the condonation or remission of the debt 4. By the confusion or merger of the rights of the creditor and debtor 5. By compensation, and 6. By novation. I am Frexizira B. Salas, and I will be discussing Section 1, by payment or performance. Now we have Article 1232. Says here that payment means not only the delivery of money but also the performance. It means that payment of debt does not restrict only to the delivering of money but also the performance. If we remember Article 1156, obligation is a juridical necessity to give, to do, and not to do. So, in fulfilling an obligation, it could be to give, which would be delivering what was promised. It could be a money, a thing, a watch, a car. An obligation to do is performing a required act. It could be building a house for someone. And the obligation not to do is refraining from a prohibited act, just like refraining my dog from entering another property. Next is Article 1233. Says here that a debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Simple means, a debt is not fully paid unless the thing was delivered or performed. An example for that, Mr. A owes Mr. B a 20,000 pesos in cash. Now, Mr. A only pays 15,000 pesos. So, the debt is not fully paid because there's still a balance of 5,000 pesos. Next article is Article 1234. If the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. So in this one, even if it's partially or substantially completed, the obligor may recover. The requisite in this Article 1234 is there must be a substantial performance and the debtor must be in good faith. An example, Mr. A obliged himself to deliver Mr. B 100 bags of cement. Now, despite all of his efforts and diligence, he could only deliver 95 because of a cement shortage. Take note that Mr. A really wants to comply with this obligation of 100 bags but cannot do so because it is out of his control. Mr. A can recover as though there had been complete delivery less the price of the 5 bags. However, Mr. A must show that he attempted in good faith to comply with this obligation. Here in Article 1235, when the obligation accepts the performance, knowing its incompleteness or irregularity and without expressing any protest or objection, the obligation is deemed fully complied with. Now, if Mr. B knows and accepts that the house is only 80% complete without any objection, then it is considered or recognized as complete or paid. So, if the house has any irregularity, imperfection, he cannot object anymore because he recognized it as already complete. In Article 1236, the creditor is not obliged or required to accept any payment or performance by a third party who has no interest in fulfillment of the obligation unless there is a stipulation to the contrary. In essence, the creditor can refuse to accept payment from a third party or the third person who doesn't have any reason to be involved in the debt. If the third party pays the creditor within the knowledge of the debtor, he can demand the debtor what he has paid. An example, Mr. A is indebted to Mr. B of 1,000 pesos. Now, Mr. C pays Mr. B 1,000 pesos in knowledge of Mr. A. Now, Mr. C can demand 1,000 pesos from Mr. A. Now, if without the knowledge of the debtor, Mr. C or the third person can only recover what he has been paid. An example is that the 1,000 debt of Mr. A to Mr. B, Mr. A only pays 400 pesos of that 1,000 pesos. Now, Mr. C pays Mr. B without the knowledge of Mr. A 1,000 pesos. He can only recover the 600 pesos he has paid. Now, that is very beneficial for Mr. A or the debtor. Now, he can reimburse all of that if the creditor or Mr. B refuses to accept his payment.
Hello everyone, I am Kat, and together with my groupmates, we will help you better understand some important concepts about Chapter 4, which is the extinguishment of obligations. I will begin my part with Article 1237. It says that if someone pays a debt on behalf of the debtor without the debtor's knowledge, or even against their will, that person cannot force the creditor to transfer the rights attached to that debt, like a mortgage, a guarantee, or a penalty. In simple terms, imagine that someone tries to help you by paying your debt even though you didn't ask them to or you told them not to. That person can now act like they're the creditor. They can claim your house or if there was a mortgage or go after your guarantor. Why? Because you didn't agree to it. This protects the debtor's rights and decisions. Now, let's move to Article 1238. This article talks about a different kind of situation. When a third person pays a debt but does not intend to be reimbursed. In other words, they're paying as a donation. This might sound generous, but here's the catch. It requires the debtor's consent. The law protects the debtor from being treated as if they received a gift they didn't want. Still, as far as the creditor is concerned, the payment is valid. If they accept it, the debt is considered paid, even if the creditor wasn't aware or didn't approve of the donation. Next is Article 1239. This article says that a payment is only valid if it is made by someone who has both the capacity and the right to dispose of the thing owed. This means that if the person who made the payment is not legally allowed to do so, like a minor, someone who is mentally incapacitated, or a deaf mute who cannot write, that the payment is not considered valid. This rule protects both the debtor and the creditor from confusion or abuse. For example, if a 15-year-old tries to pay off someone's debt without understanding the legal effects, the law steps in and says, "Wait, that's not valid." There used to be an exception under Article 1427 which allowed minors at least 18 years old to pay if it was a natural obligation. But today, that's no longer applicable because under the Family Code, the age of majority is now 18. Next up is Article 1240, which tells us to whom the payment should be made. The general rule is very simple. Payment must be made to the proper person, the one who has the legal right to receive it. Who are these people? First, the creditor, the one to whom the obligation is owed. Second, the creditor's successor in interest. This could be an heir or someone the creditor assigned the rights to. And lastly, an authorized person. This includes an agent appointed by the creditor, a court-appointed receiver, or the administrator of the estate if the creditor has passed away. If the debtor mistakenly pays someone else, that payment does not extinguish the obligation, meaning the debtor might have to pay again. That's why knowing who has the authority to receive that payment is very important. Now, let's discuss Article 1241. This article covers payments made to people who are not properly authorized or are legally incapacitated. As a general rule, payment to an incapacitated person is invalid, but there are exceptions. If the incapacitated person actually kept that thing delivered or benefited from that payment, then that payment may still be considered valid. What about payments made to a third person? Same thing. It's usually invalid unless it can be shown that the creditor actually benefited from that payment. But here's where it gets interesting. There are three situations where you don't need to prove the benefit. Number one, if the third person later acquires the creditor's rights, for example, through assignment. Number two, if the creditor later confirms or ratifies the payment. And number three, if the creditor's actions misled the debtor into believing that the third person was authorized to receive that payment. In those cases, even if the third person wasn't the rightful recipient, the payment stands. Now, let's talk about Article 1242, which protects debtors who pay in good faith. If the debtor pays someone who is in the possession of the credit, thinking they have the right to receive it, that payment is valid, as long as it was made in good faith. For example, if a creditor assigns their rights to someone else and the debtor pays that new person, thinking it's all legal and proper, the debt is considered paid, even if the assignment later turns out to be invalid. As long as the debtor acted honestly and had no bad intentions, they are protected. Finally, we have Article 1243. This one deals with situations where a court orders the debtor not to pay the creditor, perhaps due to a legal dispute or pending decision. If the debtor disobeys the court and still pays the creditor, that payment is invalid. This is a reminder that judicial orders must be respected. Disregarding them doesn't just make the payment invalid, it could also have legal consequences for the debtor.
And then we have here Article 1244 to 1247. And here, I'll present one situation in which all of that would be covered in the situation. We have here, brother who is in New York promised her sister who is in the Philippines that once she graduates at college, he will give her a luxurious bag. Sister then graduated at college. On the day the condition is met, brother offered sister a shoe instead of a bag. So here is the first question. Can brother compare sister to receive another even though the shoes cost more than the bag? Based on Article 1244, it states here that the obligor cannot compel obligor to receive another kind, even though it costs more or costs the same to what has been agreed upon. If it is to do, then therefore to do that specific. And if it's not to do, then therefore not to do that specific. And if it is to give, then therefore it is to give what has been agreed upon. And then we have here next problem. Changing the situation, if B brother promised sister to give 1 million and then once condition is met, instead of 1 million, brother gives sister a land. What would be the agreement to this? If the sister agreed to receive the land, then therefore the agreement would be dation in payment. When you say dation in payment, this refers to the mode of payment where instead of giving the monetary debt, they would give a property to satisfy the monetary debt. And then this one should be governed by the law of sales already, because it talks about property which should be governed by the sales. We have here to think differ. Why does Article 1244 and 1245 contrary to each other? It is because 1244, Article 1244, is not absolute in a way that it has exceptions. The first exceptions we have here, which is the dation in payment. Then secondly, if the obligation is facultative, when say facultative, this refers to obligation where one is demandable, but the debtor has the right for substitution. And then after that, we have novation. A novation where it could be substitute. The principal object, the debtor or the creditor could be substitute. And then lastly, if the creditor waives his right or her right. Once he waives his right, this is where he submit or he surrender his right by accepting what is already there. And then the next question we have here, on the same example, if luxurious isn't mentioned, could brother deliver the thing in an inferior quality, or can she compel brother to deliver the thing in a superior quality? According to Article 1246, we have here the rule of medium quality. When I say rule of medium quality, neither the debtor or the creditor can give an inferior or superior quality. And they were tend to deliver exceptionally good nor exceptionally poor one. This is to ensure fairness in both sides and at the same time prevent undue hardship to choose or make decision, specifically when things or specification isn't mentioned. And then lastly, we have here, from scenario above, who is in charge for expenses incurred to deliver the obligation? From scenario above, states here that the brother or the obligor is in New York, and the sister, which is the obligee, is in the Philippines. We have here what we call extrajudicial expenses. When I say extrajudicial expenses, these are the costs incurred outside the court to make the payment. Stated on Article 1247, should be on account of the debtor because he benefits into it. Though unless there is an agreement, those who's in agreed upon should pay. Sister rendered a worker for service to build a closet and tables for her, with compensation amounting to 200,000 pesos and must be made within 1 month. The workers incurred delay, reason for damages, but the amount is yet ascertained or measured. Would be, on the said date, can sister be compelled to receive only the closet? So, the first rule is that on Article 1248 states that the completeness of an obligation. Therefore, no, sister can't be compelled to receive partial payment or partial of the obligation. However, it has exception. Yes, sister can accept that if it's stipulated by the agreement that they can give the obligation partially, or from the situation above, we have here the workers incur delay, reasons for damages, and the amount is yet ascertained, meaning there is part liquidated or unliquidated. Therefore, yes, it could be partially in a way that the closet and the tables could be delivered first, and then the damages would be delivered nextly after the amount would be ascertained. And the next question, can she pay the worker using dollar if they are at the Philippines? So, on Article 1249, it states the legal tender. Basically, no, sister cannot pay or compensate the worker using dollar. It should be on the legal tender of the Philippines, which is on the Philippine peso. And then nextly, can sister pay them using checks? So, yeah, sister can pay them check only if the workers would accept the checks. Although, workers cannot accept those because checks are not part of the legal tenders. Reason for them not accepting it. And then we have here, lastly, In case the worker changes their mind after accepting the checks and want cash instead, what would happen? So basically, the thing happen is that the workers cannot have the cash because the checks would be already on the abeyance, meaning they are waiting for something already, that the check is already on hold. Here it is. Brother makes a loan of 1 million pesos on year 2010 to the bank and agreed to pay on it on year 2025. On year 2025, extrajudicial inflation happens where value of 1 peso decreases by 10%. So here is the question. How much should brother pay to the bank on the due date? So stated in Article 1250, the basis of the payment should be based on the date where the obligation is constituted, which is year 2010. On year 2010, the currency is still stable. Therefore, brother should pay 1 million only. Brother agreed to sell his only car to sister. At that time, brother's car is parked at Silang Cavite, same to his domicile. We have here question, where should the delivery happens when they did not specifically state the location? So the first thing is that if there is a stipulation, there is an agreement of the location, then therefore it follows the agreement. But if it does not, therefore it depends on the kind of the thing. If it is determinate thing, then therefore it should be the place where the obligation is constituted. So from that time, it is parked at Silang Cavite, then therefore it should be at Silang Cavite. And nextly is that if it is one of his plenty car, where should be the place of delivery? Now it is one of his plenty car already, meaning it is generic. It states here that if it is a generic thing, then this should be at the domicile of the debtor. Here, the domicile of the debtor is the same for the first one, which is the Silang Cavite. And then lastly, in case the brother changes his domicile and incur delay, what would be the consequences? So the consequences, if the brother incur delay at the same time changes his domicile in purpose, then therefore the additional expenses or damages that the creditor incur at that time would be shouldered by the debtor. And then we have here subsection 1, application of payment. Application of payment refers to how the payment of the debtor be allocated when his payment is not enough to cover all of his debt. Brother has a debt consisting of 600,000 pesos acquired 10 months ago, 300,000 acquired 3 months ago, and 100,000 acquired 1 month ago to his sister, all due on May 10. On the said date, brother has only have 700,000 pesos. He applied the payment to 600,000 pesos and 100,000 pesos. From the situation above, we could have the requisites. Going back to the situation, we have here brother and sister. The first requisite we have is that it should have a debtor and a creditor. Nextly is that from the situation, it says that brother has a debt consisting of 600,000 pesos, 300,000 pesos, and 100,000 pesos. Therefore, the second requisite we have is that the debt should have at least 2 or more. And from that, we could also say that the third requisite is that it should be all the same kind. And then nextly, we have here, it says that it's all due on May 10. Therefore, the fourth requisite is that it should all be due and demandable. And then here, it says that The brother has only 700,000 pesos on May 10. Therefore, the fifth requisite is that the payment of the debtor should not be exact or enough to cover all of his debt. Firstly, in case debtor does not make application yet paid for it, thus the creditor can make the application. So, according to Article 1252, yes, the debtor can see which of his debt is applied through the receipt that the creditor would present to the debtor. Then nextly, in case where application is vitiated or invalid, who shall govern? When we say vitiated, there is a force that impaired the quality of the application of payment. Therefore, it increases the risk to unfairness. The reason why operation of law should govern the application of payment when that happened, it is to ensure the fairness. The nextly is that in case no one can apply, what shall be considered to papers? On Article 1254, it states that the order would be the most onerous. When we say most onerous, this refers to the most burdensome for the debtor and the creditor. And then, on the example, or in the situation we presented, we could conclude that the most burdensome is the 600,000 pesos at it is acquired 10 months ago. Here are some examples of the burdensome debts. Those interest bearing, debt as a sole debtor, old debts, debts with mortgage or have been pledged, and then obligation with penal clause. Then the next one is that if all the debt is the same or same in all of them are burdensome, then it should be applied proportionately. Proportionately in a way that in this situation we have here 600,000, 300,000, and 100,000. We divide it to the payment, which result to 70%, and then 70% would be the basis of the payment or the allocation. We have here on 600, we have 420,000 pesos. On 300,000, we have here 210,000. And then on 100,000, we have here 70,000. Then lastly, in a case where there is interest, what shall be papers? Stated on Article 1253, payment is not deemed paid if the interest is not covered. Therefore, the interest should be papers, specifically if the payment is not enough to cover the principal obligation at the same time the interest.
Right next is subsection 2, payment by cession, followed by subsection 3, tender of payment and consignation that will be discussed by me. So let's begin with Article 1255, which talks about payment by cession. This occurs when a debtor who can no longer pay their debts in the usual way voluntarily assigns all of their properties to their creditors. The creditors then sell the properties and divide the proceeds among themselves. This method only applies to voluntary assignments, not those ordered by law. For this to be valid, there must be at least 2 debts and 2 creditors. The debt must be insolvent, they must willingly abandon their properties, and the creditors must accept the arrangement. It's important to note that the debtor is only released from the liability to the extent of the proceeds of the property sold, unless the creditors agree to forgive the remaining balance. Moving on to Article 1256. This article introduces us to tender of payment and consignation. Tender of payment is when the debtor offers to pay the creditor what is due, but if the creditor refuses without a valid reason, the debtor can go to court and deposit the payment. This is called consignation. This protects the debtor and is treated as if the payment had been accepted. There are also situations where the debtor can go straight to consignation without tendering payment first, such as when the creditor is absent, unknown, legally incapacitated, refuses to issue a receipt, when multiple parties claim the right to collect, or when the obligation's title has been lost. Next, Article 1257. It tells us that for consignation to be valid and release the debtor from the obligation, it must be done properly. That means notifying all the proper parties involved like the creditor and any other interested person that the consignation is happening. If this step is skipped, the consignation will not be effective and the obligation will not be considered fulfilled. Finally, Article 1258 explains how consignation is carried out. The debtor must deposit the payment or the object due with the court, present proof of the tender of payment if applicable, and notify the creditor and other concerned parties that the consignation has been made. Once this is done properly, the debtor is released from the responsibility even if the creditor still refuses to accept that payment.
Consignation, when properly made, shall be charged against the creditor. Now, an example for that is Mr. A owes 10,000 pesos to Mr. B. Now, on the exact due date, Mr. A prepares 10,000 pesos to pay Mr. B, but Mr. B unjustly refuses the 10,000 pesos. Now, here are the requisites. Debt must be due. Second, unjustifiable refusal from Mr. B or the creditor. Now, the next thing Mr. A will do is to notice Mr. B that he will file a complaint and deposit the 10,000 pesos to the court. Next is Mr. A must deposit the money or the 10,000 pesos to the court, proving that he tendered the payment to Mr. B and Mr. B unjustly refuses it. Next is Mr. A must deposit the money or the 10,000 pesos to the court, proving that he tendered the payment to Mr. B and Mr. B unjustly refuses it. Now, once the consignation is valid, the obligation is now extinguished and all of the expenses of the consignation will be shouldered by the creditor or Mr. B. In Article 1260, once the consignation has been made, the debtor may ask the judge to order the cancellation of the obligation. So as our example, the debtor is now free from the obligation. Also, the debtor may withdraw the sum of money that he deposited before the creditor accepts the consignation or before the judicial declaration that the consignation has been made. With that, the obligation remain in force or simply the debtor is still obligated to pay the 10,000 pesos. Lastly is Article 1261. If the consignation having been made, the creditor should authorize the debtor to withdraw the same, and he shall lose every preference which he may have over the thing. So here, number 1, without the authority of the creditor, the debtor can withdraw the consigned amount as said in Article 1260. And if with the authority of the creditor allows the withdrawal, meaning the obligation still remains in force, and the creditor loses the preference over the consigned amount. And lastly, co-debtors, guarantors, and sureties are released from liability. As the same example, Mr. A is indebted to Mr. B of 10,000 pesos but with C as the guarantor. Now on the due date, Mr. A offered the payment but Mr. B refused, and then we go through the process of the consignation. Now, Mr. A withdraw the deposit after securing the consent of Mr. B. Now, under this Article 1261, Mr. B shall lose whatever preference he may have over the amount, and Mr. C, the guarantor, shall be released.
Good day, everyone. I am Jodilyn Barbarona, and I'm here to discuss extinguishment of obligations, Section 2, Loss of the thing due. A thing is considered lost when it perishes, goes out of commerce, or disappears in such way that its existence is unknown or it cannot be recovered. If it's lost on determinate thing, obligation is extinguished.
For example, Mr. J, which is the debtor, should deliver a painting or specific artwork to Miss Anne. P is the painting and the delivery to Miss Anne. And then it happened to have an incidental fire or accidental fire. And since the specific painting is a determinate thing and it is lost due to accidental fire and it turned into ashes, the obligation is already extinguished.
If it is a loss of a generic thing, obligation is not extinguished or genus never perishes.
For example, Mr. J, the debtor, is intended to deliver 10 sacks of rice to Miss A. The 10 sacks intended to deliver was soaked in the flood. Mr. J is still liable to deliver 10 sacks of rice to Miss A because it is a generic thing and it can be exchanged to other type of rice.
In case of partial loss, the court is given the discretion in case of disagreement between the parties to determine whether under the circumstances it is so important in relation to the whole as to extinguish the obligation. In other words, the court will decide whether the partial loss is such to be equivalent as a complete or total loss. It is dependent on the intention of the parties as may be determined by the court. It is not automatic, it is a case-to-case basis.
For example, J as the debtor obliged himself to deliver a specific race horse to A. The horse met an accident. As a result, it suffered a broken leg. The injury is permanent. Here, the partial loss is so important as to extinguish the obligation. If the horse will be used as race horse by A, J is obliged to pay for the value of the horse plus the damages incurred. The horse will be slaughtered by A. The injury is clearly not important.
This article establishes a disputable presumption of fault whenever the thing is to be delivered is lost in the possession of the debtor. This presumption is reasonable because the debtor, who has the custody and care of the thing, can easily explain the circumstances of the loss. The creditor has no duty to show that the debtor was at fault. In case of natural calamities, the presumption of fault does not apply. Lack of fault on the part of the debtor is more likely, so it is unjust to presume negligence on his part.
For example, J borrowed the car of A. On the due date, the obligation, J told A that the car was stolen and he was not at fault. That is not enough to extinguish J's obligation. It is presumed that the loss was due to his fault. Hence, he is liable unless he proves to the contrary.
Possibility of performance will result in the extinction of the obligation. It only applies to the obligations to do. The impossibility must take place during the existence of the obligation. If the obligation is impossible from the beginning, the obligation is physically impossible, the obligor dies or physically incapacitated to perform. If legally impossible, impossible to render by the provision of law.
Here is the example of physically impossible. J is a singer and obliged to sing in a debut of A. However, 2 days before the debut, J developed a cough and her voice became hoarse. Since it was physically impossible to J to sing at A's debut, she is released or extinguished from the obligation. Here is the example of legally impossible. B agreed to construct a commercial building for F. The government refused to issue the building permit because the area has been declared by law as a residential zone. The obligation of B is therefore extinguished because it has become legally impossible. Here, the performance of the prestation is directly prohibited by law.
In Article 1267, The general rule is that the impossibility of performance releases the obligor. It is covered by element of unforeseen or fortuitous events in Article 1174. It is applicable not only to obligations to do or personal obligation, but also to obligations to give or deliver or real obligations in Article
For
1156.
example, you are a barber and you are Mr. J. You do home service and you have a trusted client living in North, which is Miss A. She is from North and you are living in South. Every time you go through to perform an obligation, you will pass Manila. It just so happened that there is a war there and it will become so difficult for you to travel and perform the obligation because it's life-threatening. Because of the difficulty, you as a debtor or Mr. J can go to the court and ask the court to release him from his obligation.
The obligation subsists except when the creditor refused to accept the thing without justification, after it had been offered to him. Consignation is not necessary. The debtor, however, must still exercise due diligence.
For example, E stole the watch of K. Here, E has the obligation to return the watch to K. The obligation of E arises from an act punishable by law. Even if the watch is destroyed without the fault of E, he shall be liable for the payment of its price.
Under this article, the creditor is given the right to proceed against the third person responsible for loss. There is no need for an assignment by the debtor. The rights of action of the debtor are transferred to the creditor from the moment of the obligation is extinguished by operation of law to protect the interests of the latter by reason of the loss.
For example, R is obliged to deliver Q a specific horse, and the horse is lost through the fault of N. H is the horse or the subject matter, and N is the third person. The obligation of R is extinguished and he is not liable to Q. Such being case, R would not be interested in going after N. The law, however, protects Q by giving him the right to bring an action to N to recover the price of the horse with damages.
Imagine being released from a debt without paying a single cent. That's the essence of condemnation or remission of debt. Good day, I'm Lorraine, Stephanie, and Brad, and today I'll explain how this works as a legal way to extinguish obligation under our civil code. So today I'll be discussing Article 1270 of the Civil Code, which talks about condemnation or remission of debt. This is an important concept in the law of obligations because it refers to the forgiveness of a debt by the creditor. And according to Article 1270, condemnation or remission is when a creditor voluntarily forgives the debtor from paying the debt. This act is essentially gratuitous, meaning it's done out of generosity and without expecting anything in return. However, for this to be valid, the debtor must accept the remission. That's a key requirement, acceptance, either express or implied. And there are three kinds of remission. First one is express remission. This is clearly stated. It is often in writing, but for this to be valid, it must follow the legal formalities of a donation. The next one is mortis causa remission. This is a special kind that only takes effect after the death of the creditor. Because of that, it must follow the requirement of a will or a testament. And lastly, implied remission. This is not directly stated but can be understood from the creditor's action. And for example, if a creditor returns a promissory note, it might imply forgiveness of the debt. No formalities are required. All remissions, whether express or implied, are subject to the rules of inofficious donation. This means that remission must not violate the legitimates or the lawful shares of the heir. especially if it's affect inheritance. Now, let's put it in a scenario. A person borrows money, say 100,000 pesos from a creditor. This loan creates a legal obligation to repay. Now that the creditor decides to forgive the debt, we now ask, how is this forgiveness expressed? That brings us the two types of condonation, the express and implied. In an express condonation, the creditor clearly and directly states that the debt is forgiven. This is typically done in writing, such as a letter saying, I forgive the 100,000 debt owed by Mr. Reyes. The debtor in return accepts this waiver either by signing the document or through acknowledgement. Once this happened, the debt is legally extinguished under Article 1270. However, express condonation must also follow the rules of donation. For example, written form if the amount is substantial. On the other hand, implied condonation is not directly stated in words. Instead, it's inferred from the actions of the creditor. A classic example is the voluntary return of a promissory note. If the creditor gives back the original loan document to the debtor without any payment, it's understood that the creditor is waiving the debt. Unless there's proof to the contrary, this action is considered valid condonation under Article 1271. Whether express or implied, condonation must meet the following conditions to be valid. First, it must be gratuitous, given freely and without payment. Second, the debtor must accept the waiver. Third, it must be inofficious, meaning it shouldn't harm the shares or compulsory heirs like a children or spouse. Failing to meet any of these conditions may invalidate the condonation. Now, let's move on to the Article 1271 and 1272. Under this article of the Civil Code, if a creditor voluntarily delivers a private document evidencing a debt of the debtor, it is presumed that the debt has been waived or settled, especially if the debtor is in the possession of the document unless proven otherwise. Now, let's move on and let's more elaborate these articles in the next slide. In continuation of our topic on remission or condonation, we now move on to an important subtopic, which is the presumptions in remission. These presumptions help us to determine whether a remission was intended, especially when it's not stated. There are two legal presumptions related to remission involving private documents, like a handwritten or printed IOU that is not notarized. Presumption of remission. If a private document of the debt is voluntarily returned or handed over by the creditor to the debtor, the law presumes that the debt has been remitted or forgiven. For example, Anna lent 50,000 pesos to Ben, documented in a signed but unauthorized promissory notes. Years later, Anna gives the note back to Ben without asking for payment. Legally, it's presumed she forgave the debt. Second, presumption of voluntary delivery. If it's proven that the document was delivered to the debtor, the law presumes it was done voluntarily, unless proven otherwise. So, if a debtor has the original IOU or promissory note in their possession and is now handed over by the creditor, that's a strong legal evidence of remission. For example, if Ben is found keeping the promissory note and Anna doesn't deny giving it, it's presumed she handed it over willingly, implying possible remission. The third is private versus public document. The presumptions only applies to private document, those not notarized, because there's usually only one copy, and giving it away means cancellation of the obligation. On the other hand, for public or notarized documents, this presumption does not apply because there are multiple official copies, and delivering one doesn't necessarily mean forgiveness. For example, if the promissory note had been notarized, even if Ben has a copy, remission isn't presumed because notarized documents often have duplicate files elsewhere. So now, I'll be discussing Article 1273 of the Civil Code, which deals with the relationship between principal and accessory obligations, specifically when a creditor waives or renounces one of them. The article states, the renunciation of the principal debt shall extinguish the accessory obligations, but the waiver of the latter shall leave the former in force. In simple terms, this provision tells us two things. In general rule, the accessory obligations follow the principal. So if the main debt is cancelled, then all the related or accessory obligations like interest, mortgage, or penalties are also cancelled. But there is an exception. If the accessory is waived, for example, the creditor waives interest, the principal debt still exists and must be paid. Give you a real-life scenario. Let's say you take out a 100,000 loan from the bank, and the loan includes 10% interest and a mortgage on your property. Here's a scenario 1. The bank renounces the 100,000 principal loan, meaning the interest and the mortgage are also automatically extinguished. Means you owe nothing. In scenario 2, the bank only waives the 10% interest. So meaning, you still owe the principal debt, which is the 100,000 pesos. The mortgage may still be in effect too. This shows how the principal obligation rule works in one direction only. The principal affects the accessory, but not vice versa. So, under this article, extinguishing the main debt wipes out everything attached to it, but waiving an accessory item doesn't erase your actual obligation. So the last thing that I'll be discussing is the Article 1274 of the Civil Code, which talks about the extinguishment of pledge. The article states that it is presumed that the accessory obligation of pledge has been remitted when the thing pledged, after its delivery to the creditor, is found in the possession of the debtor or of the third party who owns the thing. So let's break that down. In a contract of pledge, a movable party is delivered to a creditor as security of an obligation. So possession is the key here. So when the thing pledged ends up back in the hands of the debtor or with a third party who owns it, the law presumes that the pledge has been extinguished. So here are the important notes. Take note of this. Only the accessory obligation, which is the pledge, is presumed remitted. Also, the principal obligation, meaning the main debt, still exists unless there is a separate reason for it to be extinguished. Like for example, Anna borrows 20,000 from Ben. To secure the loan, she pledged her expensive watch and hands it over to Ben. A few weeks later, Anna sees Ben wearing her watch and then Ben casually returns it to her without saying anything. So, it has an effect under Article 1274 because the thing pledge or the watch is now in Anna's possession. The pledge is presumed extinguished, even if the loan remains unpaid. However, Anna still owes the 20,000 pesos. Only the pledge, the accessory obligation, is considered waived or remitted. So, why is it important? This rule protects both parties and promotes clarity. It avoids hidden or implied claims over a thing that's no longer in the creditor's control. So, to sum it up, the Article 1274, the pledge required possession. So, if the debtor or the owner regains possession, it's presumed that the pledge is remitted. Only the pledge is extinguished and not the principal debt. So that's all for the condonation or remission of debt.
In an obligation, if the debtor and the creditor are merged in the same person, what do you think will happen? Good day, I am IZ Amoroso of BSA 11 and I am here to discuss and elaborate the concept of confusion or merger of rights, which is one of the possible causes of extinguishment of obligation. In case that the debtor and the creditor are merged in the same person, the obligation will be extinguished. But it will only be valid if it happens between the principal debtor and the principal creditor of the same obligation, and merger is definite and complete. And that is the time when obligation will be extinguished through confusion or merger of rights. And in that case, accessory obligation of guarantee will also be extinguished in accordance to the general rule that accessory follows the principal. And if that happens, it would benefit the guarantor. Guarantor is another party who promises to fulfill the obligation in case that the principal debtor fails to do so. So if the principal obligation is extinguished, the guarantor doesn't have any obligation to pay anymore. But what if confusion happens in the guarantor? Would that result to the extinguishment of the obligation? Well, the answer is no, because accessory does not carry the principal. Another thing, if confusion takes place in a joint obligation in which debt or credit is paid, fulfilled, or demanded proportionately by different debtors or creditors, confusion will extinguish only the share of the person who become both the debtor or the creditor. On the other hand, if it happens in a solidary obligation, it shall extinguish the whole obligation and the person can demand reimbursement from the other debtors. For us to understand the concept better, let's put it in a situation. So the situation is, Blossom, Bubbles, and Buttercup are jointly liable to Mojo Jojo in the amount of 90,000 pesos with Miss Bellum as guarantor of the debt. So Blossom inherits the right of Mojo Jojo as Mojo Jojo assigned his credit to Blossom. So she became both the debtor and the creditor. So we can say that Blossom's debt is extinguished and she no longer owes Mojo Jojo the money because Blossoms become both the debtor and the creditor and the debt is complete and definite. As a result, the debt is extinguished because the same person cannot owe and be owed the same debt at the same time. And because confusion happened in Blossom, which is a principal debtor and the creditor, this benefits the guarantor Miss Bellum as the accessory obligation follows the principal obligation. So, Miss Bellum is now only liable for the remaining 60,000 pesos, which is Bubbles and Buttercup's debt if they fail to pay. And if confusion had happened in Miss Bellum, the obligation would not be extinguished because confusion only occurs between the principal debtor and the creditor, and the extinguishment of the accessory obligation doesn't carry the principal obligation. And only Blossom's 30,000 pesos debt is extinguished due to confusion, but the indebtedness of Bubbles and Buttercup in the remaining amount still occur because there is no confusion that happened to them. So, both Bubbles and Buttercup would be jointly liable to Blossom, the new creditor, in the remaining amount of 60,000 pesos. And in case that the obligation is solidary, confusion of rights with Blossom extinguishes the entire obligation since Blossom in the first place is also liable for the full amount of the obligation. Now, Blossom can demand reimbursement from Bubbles and Buttercup. And that is the concept of confusion or merger of rights.
We will now be discussing Section 5 of the Chapter 4 Extinguishment of Obligation. Good day, this is Juana Michael Lamas of BSA 11. Section 5 is compensation, which is a mode of extinguishment to the concurrent amount when both parties are reciprocally creditors and debtors of each other. In simple terms, it is generally considered as a form of offsetting, which in Philippine law, compensation is referred to as offsetting of obligations.
For example, in this is if A owes B 50,000 pesos and B then owes A 25,000 pesos, 5,000 pesos, and 20,000 pesos, which came up with a total of 50,000 pesos as well. Instead of paying each other, then they can offset it and not pay each other as the concurrent amount is extinguished. Can the amounts be lump sum? Yes, it can be as long as the obligation is within the same part. These are examples of the kind of compensation as to extent which is total, since the entire obligation is extinguished. Can compensation be applied if the amount is different? Yes, it still can. Compensation can also reduce mutual obligations. This is the kind of compensation as the extent of partial, since only part of the obligation is extinguished. An example of this is if A owes B 50,000 pesos and B owes A 25,000 pesos only, then A still have to pay the remaining 25,000 pesos that they owe to B. These kinds of compensation as to extent, which is total or partial, is under Article 1281. For the kinds of compensation as to cause or origin, first is legal. It occurs automatically by the law because all requisites of compensation are present even if parties are not aware that the obligation is extinguished. There are 5 requisites of compensation. First, both parties should be principal debtors and creditors of each other. If A owes B, then B should owe A. Compensation can be A owes B, then B owes C. Or even if A, which is agent or has the right to collect on behalf of C, owes B, then B owes C, since technically the obligation of B is to C and is still not to A, compensation can happen. However, under Article 1280, it says that no compensation if one party is only a guarantor, except when guarantor is forced to pay. An example to this is A owes B 50,000 pesos, then B owes A 25,000 pesos. B is demanding A to pay already. However, A is unable to pay yet. Since the G is the guarantor of A, G is required to pay. G will only pay B 25,000 pesos since B owes A 25,000 pesos. Second requisites of compensation is that should involve money or fungible items, which is essentially equal in value. Example is A owes B 50 liters of oil, then B owes the same, then A and B can just offset it or take it as a compensation. However, if A owes B 50 liters of oil, then B owes A unique painting, then obligations can be offset since unique painting is a fungible item. Third and fourth requisites of compensation is that debts must be due, liquidated, and demandable. However, it is not necessary that both are due at the same time. One debt may have been due earlier. However, both must be liquidated to have exact amounts determined already. Both must be demandable as well for debt to be owed already. Example to this is A's debt to B is due by January 31st. Then B's debt to A is due by February 1st. Compensation can only be done by February 1st as both debts are already due and can be demanded and have the exact amount already by then. Last requisites of compensation is there must be no claim from a third party, as claims needs to be validated first before legal compensation can take place. All these 5 requisites of compensation are under Article 1279. Next kind of compensation as to cause or origin is conventional. Conventional is agreed upon parties even without all legal requisites. This is voluntary compensation. Agreement of both parties are already sufficient to declare compensation as valid. This is under Article 1282. However, under Article 1286, it sees the limitation of conventional compensation. It applies to legal compensation, which is whoever claims compensation will be liable for the expense of transportation. Example to this is A owes B 1,000 US dollars payable in New York, while B owes A 100,000 pesos payable in Manila. A claims compensation. Therefore, A must pay for expenses of currency exchange, which is the expense of transportation. Last kind of compensation as to origin or cause is judicial compensation, which is ordered by the court, wherein all requisites of compensation are present except at the time of pleading, the claim is not yet liquidated since there is still a claim for damages that can offset the concurrent amount. Voidable debts are valid until annulled. If the voidable obligation is later annulled, the compensation is also annulled retroactively. Therefore, example to this is A owes B 50,000 pesos. A was able to let B sign a promissory note that B owes A 50,000 pesos, which is considered fraud. A's debt is valid. B's debt is voidable, however, it is valid until annulled. So, compensation can take place. B filed a case to nullify the debt to A. Court decided in favor of B, therefore A is still liable for their debt since there had been no compensation. In Article 1285, if compensation has already occurred, assignments of rights made by a creditor in favor of a third person is already ineffective because the obligation is extinguished. Consent and notification by the debtor are essential. If the assignment was made with the consent of debtor, compensation can be set up due to consent that makes waiver of the compensation. Example to this is A owes B 50,000 pesos, B owes A 25,000 pesos, B assigns C, then C can collect entire amount of 50,000 pesos to A. But if A reserves his right to the compensation, C can only collect remaining amount of 25,000 pesos to A after compensation. If the assignment was made with the knowledge of debtor but without the consent or against the will of the debtor, compensation can be set up regarding debts previous to the assignment. Example, A owes B 50,000 pesos due on January 31st, B owes A 75,000 pesos due on February 1st, A assigns C with knowledge but without B's consent by February 5th, A owes B 25,000 pesos due on February 15th. Therefore, C can only collect 25,000 pesos to B since there had been compensation happened in respect to the debts previous to the assignment. If the assignment was made without the knowledge of the debtor can set up compensation as a defense for all debts maturing prior to his knowledge of assignment. Crucial time is time of knowledge of the assignment. In example, A owes B 50,000 pesos due on January 31st, B owes A 75,000 pesos due on February 1st, A assigns C without B's knowledge by February 5th, A owes B 25,000 pesos due on February 15th, B learned the assignment by February 25th. Therefore, all debts can be compensated. There are 4 instances where compensation cannot take place. 3 of it are under Article 1287. First is when one of the debt arises from depositum, wherein you provide an object for safekeeping purposes to another person. Depositor is the sender, depositary is the recipient, and depository can take the object deposited as a compensation. Example is, if A deposited 10 sacks of rice to B and A owes 50,000 pesos to B, B still needs to deliver the 10 sacks of rice and can't refuse since it is depositum wherein compensation shall not be proper. Second is baili incommodatum, wherein baili can't refuse to not return the bail or the object possessing under bailment agreement, since this can't be used as a form of compensation. Example is, B borrowed car of A and A owes 250,000 pesos to B. However, B cannot refuse to return the car claiming compensation. But if A or the bailor initiates to use bail as form of compensation and B agreed, it can be conventional compensation. Lastly, support by gracious title. Premise of support is required for purposes of sustenance or survival. Therefore, compensation is not proper if obligation arises in legal support. Example is, A gives legal support of 25,000 pesos per month to B, which is their minor offspring, and B owes A 25,000 pesos. A cannot compensate their obligation to support B by what B owes to A. Last instance where compensation cannot take place is under Article 1288, which is when one debt consists in civil liability from a crime. Example is, A owes 50,000 pesos to B, then A and B had fought. Then, B inflicted A physical injuries. So, A filed a case against B. Court favored A and ordered B to pay A 50,000 pesos. This applies the principle a person criminally liable is also civilly liable. However, B can still demand A what A owes to B since it is a different and separate situation. But A, which is the victim, can initiate to use civil liability as form of compensation, and if B agrees, it can be conventional compensation as well. For Article 1289, parties may choose to waive the benefit of compensation and keep the obligations in effect. However, most onerous rule applies. Example to this is, A owes B 50,000 pesos. A also owes B 50,000 pesos with 3% interest. Then B owes A 50,000 pesos. All debts are due on the same day. Then no one informed which on the due debts will be compensated. Therefore, the 50,000 pesos with 3% will be compensated to the 50,000 pesos B owes to A. Then, 50,000 pesos that alone will be left. As mentioned earlier, as long as 5 requisites of compensation is present, it automatically extinguishes both debts to the concurrent amounts even though the creditors and debtors are not aware of the compensation. This is under the Article 1290. Take note, in compensation, there is always at least one obligation that will be totally extinguished, and compensation is done for the purposes of convenience.
Shiloh borrowed 17,000 from Tyler, payable in 6 months. 2 months later, Shiloh asked if he could transfer ownership of his motorcycle instead of the 17,000 in cash, and Tyler agreed. This is an example of novation. Novation is the extinguishment of an obligation by substituting it with a new one. Before the motorcycle could be transferred, his brother Rick offered to take over the obligation and transfer his own motorcycle of similar value, and Tyler agreed in writing. This is a passive subjective novation, a change of debtor with the creditor's consent. As the result of changing the debtor, Shiloh, the original debtor, are now released. from the obligation as Rick becomes the new debtor. Tyler then decided to assign the right to receive the motorcycle to his sister Chloe, and Rick agreed to deliver it to her instead. The parties sign a written novation agreement. This is active subjective novation, a change in the creditor with the debtor's consent. As a result of the novation, Chloe takes on the position of the new creditor, effectively replacing the original party in the agreement. This means she now has the legal right to receive the motorcycle as per the terms of the arrangement, with Rick being obligated to deliver it to her instead of Tyler. Later, they all agree to change both the object and the parties again. Rick will now deliver a brand new laptop instead of a motorcycle, and the recipient will be Chloe's husband, Brent. Everyone signs a new agreement. This is a mixed novation, both the object and the parties change. As a result, the most recent agreement completely overrides and cancels out the previous one, leaving it null and void. The new contract not only substitutes the original object of the agreement with a brand new laptop, but it also alters the parties involved, shifting the recipient from Chloe to her husband Brent. This is effectively dissolves the earlier contract and replace it with the newly updated terms. Was the original loan between Sheila and Tyler extinguished? Identify and explain the types of novation that occurred. The original obligation between Sheila and Tyler was extinguished through a series of novation. First, objective novation occurred when the object of the obligation was changed from $17,000 to a motorcycle. Second, passive subjective novation followed when Rick replaced Sheila as debtor with Tyler's consent. Third, active subjective novation happened when Tyler was replaced by Chloe as creditor with Rick's consent. And lastly, four, mixed novation finally occurred when both the object laptop instead of motorcycle and the parties Brent as new creditor were changed. Each novation was valid because it involved a prior valid obligation, a new agreement, consent of all parties involved, and incompatibility with the previous obligation.
There are two types of novation classified as to its form, which is either express novation and implied novation. Novation is never presumed unless explicitly declared by the parties or by the incompatibility of the two obligations. All of the cases mentioned earlier are express novation because it is declared by the parties that the new one will replace the old obligation. In the first case, without the declaration of the parties, novation cannot be presumed. The two obligations are not incompatible because Sheila can give Tyler his motorcycle while also giving him $17,000, making the two obligations stand on their own. In the third case, however, Rick cannot give his motorcycle both to Chloe and Tyler, making them incompatible. Hence, the new one novates the first. There are two possible scenarios when changing the creditor. It's either ex permission or without the initiative and the consent of the original debtor, or delegation where it is the debtor who initiates the substitution. Let's say in the second example, Rick, a third party with the consent of Tyler, the creditor, takes over the obligation without the knowledge of Sheila, the creditor. Sheila is now fully released from the obligation even if Rick becomes insolvent. This is an example of ex permission. Let's say, in the same example, Sheila is the one who initiates that Rick will take over the obligation. Sheila will then be again released from the obligation, but if Rick was already insolvent, the obligation revives and Sheila would then be liable for the obligation. As the general rule, the accessory follows the principal, meaning when the novation extinguishes the principal obligation, it also extinguishes the accessory obligation except those that are beneficial to a third party who did not give their consent. For example, $17,000 that Sheila owes to Tyler bears a 20% interest. It is stipulated in Tyler and Sheila's contract that the 20% interest would be given to charity instead, a third person to their agreement. 2 months later, They agreed that Shiloh would then deliver his motorcycle instead. Despite the extinguishment of the original obligation, the $17,000, the accessory obligation that Shiloh must pay charity the 20% interest or the $3,400 still exists unless the novation is with the consent of charity. One of the requisites of novation is that the new obligation must be valid. If the new obligation is void, so is the novation, meaning the old obligation shall subsist. Another requisite of novation is a previous valid contract. This means that if the original obligation was void, novation cannot take place as there will be no obligation to replace in the first place. If the obligation is subject to a suspensive or resolutory condition, the new one shall honor be the same condition, unless there is a stipulation to the contrary. For example, in the first scenario, let's say that it is part of their agreement that Shiloh would only pay the $17,000 once Tyler becomes a father. The new obligation, which is to deliver the motorcycle, shall also be under the same condition, unless it is stipulated by them. The reason behind this is that as long as Tyler is not yet a father, there will be no obligation to replace in the first place. Hence, the novation cannot take place. Subrogation, or where the third person, a subrogee, takes the place of the original creditor, the subrogor. This gives the subrogee all rights that the subrogor have. It is either legal or conventional, legal not being presumed except for some cases. Cases number 3 and 4 that are mentioned earlier are conventional subrogation because it includes the consent of all of the parties, including the third person. Legal subrogation takes place within the operation of law even without the consent of the parties. It can only be presumed in these three situations. First, when a creditor pays another creditor who is preferred even without the debtor's knowledge. Sheila owes Tyler $17,000, making Tyler his creditor. Sheila also owes Ray $15,000, thus he pledged his land as a security. This made Ray a preferred creditor. Tyler pays $15,000 to Ray, who is a preferred creditor. In this scenario, Tyler will be subrogated to the rights of Ray even without the knowledge of Shiloh. He will become the new creditor, and Shiloh will owe him the $15,000 that he owes Ray, including the land that he pledged. Number 2. When a third person not interested in the obligation pays with the express or tacit approval of the debtor. For example, Rick owes Tyler $15,000. Chloe, with an approval of Rick, pays Tyler the $15,000. Chloe will then be subrogated to the right of Tyler via the operation of law and will become the new creditor of Rick. In another scenario, however, let's say that instead of paying the $15,000 in whole, Chloe only pays $10,000, making a partial subrogation. Chloe will be subrogated up to the portion that she paid. In this scenario, when Rick becomes insolvent, Tyler, who still Rick owes $5,000, would become the preferred creditor and the first one to receive payment from his asset. Chloe would then be followed. Number 3. When even without the knowledge of the debtor, a person interested in the fulfillment of the obligation pays without prejudice to the effects of confusion as to the latter's share. For example, Jasper was the guarantor of Shiloh, who owes Tyler $17,000. Jasper, even without the knowledge or approval of Shiloh, pays Tyler the $17,000. Jasper will then be subrogated to the right of Tyler and will become the new creditor of Shiloh.